All right, and we are live.
Hello, everybody. We are live. It's Aaron Hall and Zach New and Rylan Warner. We're attorneys, immigration attorneys at Joseph and Hall, and we're here for the weekly update. So let's just get right to it. We're going to go through a few topics that we had planned and then get to questions. So we'll get to your questions. Just put them in the comments there, and we will go through them after we get through some of our opening stuff. So I'm going to start. I wanted to talk about a couple of things for people in removal proceedings, and that is immigration court in the United States. So the first thing I wanted to talk about was prosecutorial discretion. We've discussed this on some of the prior calls, but I wanted to give an update or kind of a non-update on where that stands. So you can think of prosecutorial discretion as, the decision of an immigration officer or a lawyer who works for ICE about what to do with an enforcement decision. So for immigration officers, that might be whether to put somebody into removal proceedings, whether to arrest them, whether to detain them, or if they already have an order of removal, which is an order of deportation, whether to deport them then or give them a stay of removal and let them stay for a while. So these are decisions in the discretion of immigration officers. And then on the lawyer's side, there's decisions about what to do with cases that are in removal proceedings, so before the immigration court. Examples of things that they can do are, move to terminate the case, decide it's not really a priority, so we don't need to have this person in removal proceedings. Or join with the immigrant or their lawyer in a motion to grant relief, or decide not to appeal a decision granting relief, or withdraw an appeal. Well, on the immigration officer's side, they have their priorities and they are starting to implement them. And when there's a decision that's made that we don't think is in conformity with the priorities memo that ICE has put out in the Biden administration, then there's actually a way to elevate that and ask for review from headquarters in Washington, D.C. There's not yet anything similar with the lawyers who work for ICE, who do the cases in immigration court. And so we haven't seen a lot of positive movements on cases in removal proceedings, either before the immigration judge or at the Board of Immigration Appeals. Supposedly, that is about to change, maybe even in the coming days, probably in the coming weeks. There's going to be guidance that's released that's going to open up a lot of different options for different people. So we're still waiting on that to get released. Supposedly, it will be made public. Their previous iterations of these kinds of memos have been private. They haven't been released publicly. So we'll get a good look at what the possibilities are and be able to advise individuals on what it means for their case. So we're really looking forward to that. We're hoping that it opens up different options for lots of different clients. The next thing I wanted to touch on briefly was a case that's before the Supreme Court. It's called Niz-Chaves. And this is a case that is about this form of a relief called 10-year cancellation of removal. It's really the most common form of relief in immigration court, probably across the board. It's the most common form of relief. And if you win it, you get to become a permanent resident. Well, one of the requirements for cancellation of removal is that you have spent 10 years in the United States prior to the application. But that time accruing cuts off upon certain events. So certain convictions make that clock stop, so you can't accumulate the 10 years after that. Or the issuance of what's called a notice to appear. So that's the charging document that puts you into immigration court proceedings. Well, the Niz-Chaves case is about whether, when it's a defective notice to appear, when it doesn't contain all the information that's really required for a notice to appear, whether that actually cuts off the time. And why that's important is because for I don't know, as long as I've been practicing immigration law, almost all of the notices to appear are defective. They are not, they don't contain the legally required information, and specifically the date of the first hearing. So right now in Denver, where we're based, if it's a defective notice to appear, it doesn't cut off the timeline. That opens up cancellation of removal possibilities for, I don't know, tens of thousands of people who are in removal proceedings. And that's based on a 10th Circuit case. But the Supreme Court's reviewing the issue, and they've already heard our argument on it, and we're going to have a final decision one way or the other in probably the coming weeks. And that's going to have a big impact on people in removal proceedings either way. It's either going to be a good thing that keeps people eligible to apply to stay here, or it's going to be a very bad thing that knocks a lot of people out of eligibility. So that's something we're keeping our eye on, and we'll certainly keep you updated on it. For our next topic, I wanted to pass it over to Ryland Warner. I know he was on last week's call, but I don't know whether he actually got the chance to really introduce himself. He's our newest attorney here at Joseph and Holland. So, Ryland, why don't you start by giving yourself a little introduction?
Yes, hello, anybody that saw me here last week. I know I was having some technical difficulties, so I couldn't really talk to you at the beginning of the meeting, but my name is Ryland Warner, and I am a recent graduate from Colorado Law, just like these two fellows sharing the screen with me. I grew up really close to where our law firm is located, and I am really excited to be part of this team. I've always wanted to be working in immigration law, and here I am. So I'm so happy and proud to be here right now. For my topic today, I wanted to talk about a bill that passed in Colorado regarding U visas. So if you're not aware of what a U visa is, it is a pathway to legal permanent resident, and it's usually designed for people that do not have status at the moment. And so the idea is, if you were the victim of a crime and you cooperate with law enforcement regarding that crime, then that can get you this U visa, which would put you on the pathway to lawful permanent residency. So it's a really great opportunity. I mean, it turns something that could have been really terrible into something really good for a person that didn't have status. But one of the issues with it, at least in Colorado, was that you needed to get these certifications from the law enforcement offices regarding how you helped in the prosecution of the crime. And the policies of how these certifications were issued varied all over the state, and they could take a really long time for the police office to actually issue the certification, up to years that people were waiting. They had already helped in the prosecution of this crime, but they weren't getting anything from the benefit that they were supposed to be getting. And so this bill, all it does is it makes unified all the processes that law enforcement officers are supposed to follow in issuing these certifications. And it gives deadlines so that there needs to be a response within 90 days of the submission of the application for certification. And so it's a great thing that people are not going to be having to wait in limbo anymore, seeing whether or not they're going to get this, and that they can actually move forward with their lives. It's really great, and I'm really happy that we were able to do this in Colorado. That's all I have for my immigration update for this week. Zach, do you have anything?
Sure. So just like always, I'll talk about H's. I know there's a lot of questions about the lawsuits right now. We'll get to those. First, we're just doing some quick updates on, I guess, what's going on in the immigration world, and then we can talk lawsuits and any other questions that we've got. So I was going to talk about H-2Bs. These are for non-agricultural temporary workers. It's a program that's largely used by things like landscaping companies, ski resorts here in Colorado, things like that. As background, there's 66,000 visas available per year. They're split between the two halves of the fiscal year. So jobs with a start date of April 1st and jobs with a start date of October 1st. As you can probably imagine there's a bigger need in the summer for kind of a supplemental workforce. So the visas, the 33,000 visas for the summer season are used up almost immediately. Because of that, employers are kind of out of luck if they don't get selected in this initial. It's kind of a lottery, just like the other H's that we talk about. Thankfully, Congress in almost every year will issue some supplemental visas, and DHS will then release those visas out to be processed, and employers can then bring in more workers. This year, we just got an announcement, I think it was 2 days ago, from DHS about when they were going to be releasing visas and how many. Congress had authorized them to be releasing these visas back in December. We had heard June was kind of when they were going to be looking at this, but about 2 days ago, Department of Homeland Security said, yes, we're going to release 22,000 more visas for this April 1st start date or later H-2B filing season. And yeah, now we're kind of just waiting on when that will happen. The estimates are kind of mid-May. I suppose anecdotally we've heard that the Department of Labor wasn't really involved in this announcement, so they're kind of scrambling as well. So we could see new visas released for H-2B employers as early as mid-May. Something to keep an eye out for. The other thing I wanted to kind of give an update on is the visa bulletin. I did see some people had already tuned into Charlie's chat about the visa bulletin and where it's predicted to go. But there's some potentially interesting developments that are going to happen on October 1st that could help a lot of people out with obtaining permanent residency. So just as background to that one, there's an annual worldwide limit of 675,000 immigrant visas available. They're split between employment-based visas, family-based visas, and diversity visas. You can kind of think of it, around 75% of them go to family-based visas, about 20% go to employment-based visas, and then about 5% go to diversity visas. Numbers are not exact, but around that much. And that means there's just not enough visas available for everybody in the world. Compounding that, in order for one country to not kind of like scoop up all of the immigrant visas at once, there's a cap on 7% of those visas per country per year. So folks who are from India or from China, for mostly those two countries on the employment-based side, have massive waits in order to get their green cards. After they've had an employer sponsor them and they've gone through the whole process to actually apply. What we saw last year because of COVID, all the unused visas from the family-based side kind of roll over into the employment-based visa. I guess that's a pool of visas available. This made priority dates, what they're called, just jump forward massively, and all of a sudden, just hundreds of thousands of people were able to apply for permanent residency in October, which kind of, I suppose, released them from their dependency on these non-immigrant visas that they've been on for many years. And this year, I think that we're expecting kind of the same thing. There's been, again, COVID has significantly limited the ability for immigrant visas to be issued. And in addition to that, we've got these presidential proclamations that have been in place for a very long time. I mean, it was from April and June until March that were restricting immigrant visas from being issued. So most of the immigrant visas will not be used up and should be rolled over into these other categories, and we should see priority dates jump forward just massively as of October 1st. That'll open up an opportunity for specifically Indian and Chinese nationals to apply for permanent residency, and it's a really exciting thing. When you wait in line for a decade, it's always really great news when you get the chance to finally take the next step. I suppose that could be my update, and we can jump into questions. I see that's really everything everybody wants to talk about is this lawsuit. So why don't we do that? All right, so Gomez, did all plaintiffs receive relief in that case? So that case is not resolved yet. Summary judgment is briefed, and the judge is pending decision on that case. But to my understanding, that not all plaintiffs have received relief, otherwise there'd be no need for this final step of summary judgment. And we're still waiting on the judge to make a decision on not only the diversity visas, but whether he's going to kind of expand the ones that he had already reserved. Not all plaintiffs have received relief, and the case is not over yet.
All right. So the question is about what is the update on Go. Go is the DV 2021 case that was filed in the District of Columbia on April 9th. The update is as follows. So Chuck has been going back and forth with the lawyers from the Department of Justice, actually just trying to get a hold of who's going to be assigned to the case. The reason is as follows. We want to talk with them and see whether they think it makes sense to get a more or less immediate hearing before Judge Mehta. And then, if so, the idea behind that hearing would be to get everybody on the same page regarding a motion for summary judgment. We've discussed on previous calls that there were going to be motions for preliminary injunction, summary judgment, or both, and that we were still making some strategy calls. Right now, we're leaning towards just a motion for summary judgment because it could resolve everything up front rather than just a preliminary ruling. And so we are waiting for that communication to keep going. I imagine we'll have more news, more concrete news in the coming days, or maybe early next week, about what the schedule is going to be and whether we're going to get a hearing with Judge Mehta right away. But that's the update, and thank you to all the Go plaintiffs who have sent along evidence of their efforts to transfer their cases, and we are certainly going to be using some of those as exhibits in the filing that we do. So thank you.
So my understanding is that this would not work. The embassy will schedule you for an interview, and you go from there. I have not heard of anybody successfully booking their own K1 appointment and having that go through. I've heard of people trying and it being canceled, but not anybody booking it and then actually having that appointment actually follow through. So I would say hold tight. I know London's being a problem right now, but they are moving from what I understand. It's just a lot slower than we'd like. Kinsley injunction has not been filed yet. Kind of like with Go, there's a bit of a strategy decision going on here on whether we're going to be doing that preliminary injunction, TRO at the beginning, whether we're going to be moving for summary judgment right away, or whether kind of going to be doing a combination of both. It's still an ongoing discussion. So once we've got that strategy figured out, it should be filed very shortly after that. But there's just kind of some behind the scenes stuff that needs to be worked out on how this is going to be proceeding before that gets filed. So K1 lawsuit. So this is not a travel ban country. So really, it's a unique situation where we're saying, hey, Cairo has not been processing K1 visas. This is for everyone who's not this individual. Obviously, this person knows. We're saying basically, hey, Cairo is not subject to a proclamation restricting entry. So there's no visa policy. They're just not processing visas. And beyond that, there's no reason for them to not be processing visas. The COVID rate is so low in Egypt compared to the U.S. They really can get going at any time. After filing the case, 7 couples from the group who were stuck at NBC tried to send emails to the Cairo embassy and NBC saying they were plaintiffs and asking to process the case. That could be helpful, but also we don't have an order from a judge yet saying that they have to process cases. I say what you should do now, keep it up. We're saying, do that about weekly until, you have an answer, and then we can use that as exhibits when we're actually filing for an injunction in this case. timeline on the lawsuit is shortly after this, we'll get everybody's declarations together and file an injunction, kind of like we did in Milligan, saying these things need to be processed now, and the judge will rule. The timeline in DC is we'll file the motion. The other side gets 21 days to respond to that motion, and then we get 14 days to reply to that response. And then the judge basically gets as much time as they want to make a decision. It's normally pretty quick in the case of a temporary restraining order or a preliminary injunction, but that's, I guess, the general timeline. As far as the timeline overall, it's hard to say. I mean, things will be developing as the case progresses.
All right. I see this one references something I said in the past, which is always a little bit scary, but hello, Eddie. So the question is for K1 entrants, how to prove that, or how to get evidence of work authorization. So there's a few ways to do this. So, the most typical way is you actually just come in, you get married, and then you file your adjustment of status. And with the adjustment of status, you file for your work authorization. It's also possible to come in and file for a work authorization document before you get married or before you apply for your adjustment of status. If for some reason it's going to take some time to get the adjustment filed, then that might be worth doing. But usually if you can file the adjustment quickly, then there's no need. The question that Eddie has here is, what about work authorization before any of that, just upon entry? And the K1 entrants are actually work authorized incident to status. That means that the regulations say that they are authorized to work just because of their status as a K1 visa holder in the country. The problem is, how do you get evidence of that? And the process to do it is normally filing to USCIS, and that takes whatever, 3 to 5 months. In the past, what Eddie references here is, I said that you could, upon entry to CBP, note to them that, hey, I'm work authorized, incident to my status. Can you put a stamp in my passport that says basically work authorized during the time my K1 stay is valid? And sometimes they would say, yes, we can do that. Or they would get a supervisor who would say, yes, we could do that. I know that because I've seen it happen. But my understanding is that they're doing it less often than they used to. And there may be some officers who don't even know that they can do that. And so you would, again, need to ask to talk to a supervisor. So that's kind of the way that's worked. I don't know if you have other experiences with that, Zach.
No, I was just going to give the citation if you like this, Eddie. It's 8 Code of Federal Regulations, so 8 CFR, section 274A.12. So there's the regulation if you want to look it up. It's it says that K1 visa holders are work authorized incident to status with evidence of evidence by an employment authorization document from the service. So, anyways, yeah, basically what Aaron said. That's the regulation, and yeah, I think we can move on. There we go.
Do you know the answer to this one, Zach?
So the only folks in GOMEZ that I was working with, we did not have to do that. So it's possible, but at least the folks I was working with, we didn't need to. So I just don't know the answer to that one.
In Go, a lot of the plaintiffs are doing this right now, are requesting transfers from consulates that aren't working very much to consulates that may be working a little bit more, even though probably not very much on DV 2021 visas from the statistics we've seen. But they've almost universally been met with no, we're not going to make that transfer. And so they're sending us that, and we're going to include it as exhibits in our filing. let's see. Abdo asks about the visa bulletin showing DV 2021 as current almost across the board. And will that help plaintiffs with high case numbers? I mean, yeah, maybe. What it does is it removes any excuse for the government not to work on the cases or not to process cases due to the case numbers. And so if you can, it's not the only problem. The bigger problem for lots of people is just that they're not scheduling interviews. They're not interviewing people and getting this done. So it doesn't resolve that, but you were able to tell the consulate and KCC in good faith, hey, my case should be ready to go. It's current. And so, yeah, it could help people with higher case numbers. The question from Brianna is, if you're in litigation and the relationship is over, do you need to cancel anything or let it expire on its own? Are you talking, what relationship are you talking about? I'm not sure I understand the question. I don't know if you're talking about the relationship to the attorneys or to a fiance in a K1 litigation. I just don't know.
If it's with us, then no. If you have broken up with your fiance or something like that, though, you definitely need to let us know, because then your case is not able to move forward anymore, and we need to dismiss you.
Yeah.
All right, where the Milligan suit stands. Timelines on the next status report. What can we expect to happen? Round 3, London, still embassy. The kind of last status report, I think everybody talked about that on the call Monday, the impact call. The status report was sent off kind of saying, this is where we stand, and now we're ready to move forward with the government answer. I believe the government answer is due on the 6th of May. So they're either going to, respond to our complaint and say, basically we disagree with everything you said, or they're going to file a motion to dismiss, which is going to be a motion to dismiss. Our response is due later in May, and the case kind of goes from there, and then we're actually getting to the point where we're litigating individual cases. So there's not really a next status report so much as the case gets moving, if that makes sense. And I mean, I guess that's probably a poor choice of words. The case has been moving, it kind of in an informal way where we're working with the government attorney. This is just like, getting the actual case in front of the judge and having timelines in front of the judge, rather than having things be informally negotiated. Any news from the London embassy? So I've heard Kinsley, we don't have a lot of folks who've been using the update form, so I don't have a lot of specific updates from Kinsley plaintiffs. I've heard anecdotally from people that there's been movement for a lot of Kinsley folks. London, I know, has been an issue. Just I'd say keep emailing. I know we're just getting the generic response, but that's still something we can say to the judge. Hey, weekly these plaintiffs have been emailing both the NBC and the London embassy, and they're getting nothing. There's not even responding anymore. So yeah, it's just keep it up, and we'll be pushing that along when we get the injunction or the motion for summary judgment.
And this isn't talking out of turn, because this was announced on the call on Monday. But one update from the London embassy is that Mr. Kinsley himself, who is the lead plaintiff named in the suit, was issued his father was issued the visa from London this week. So something's happening there. I know not enough.
Yeah, so it's moving, just slowly enough. Yeah.
Let's see, when will Go be filed, and when can we expect a ruling from Judge Mehta? Well, the case is filed. The case is filed, and the clock is ticking on the government to issue their answer to the complaint we filed. So that's happening. what we're doing next is not just waiting for that, just because it's so time sensitive. So we're going to proactively file a motion for preliminary injunction or summary judgment, likely for summary judgment at this point. But like I said earlier, we're going to make sure that Judge Mehta is on board with the timeline and with how the case is going to be handled, and then do it from there. As to when we can expect a ruling, I don't know. Zach laid out the timeline for what these look like. It's there's 21 days to respond to the motion, and then the reply, and then it's just going to be in Judge Mehta's hands whether he wants to hold a hearing about it or just issue a ruling on the written arguments. We don't know, and we also don't know his timeline.
Especially if we go for summary judgment right away. I mean, that can take a really long time. Just one example, this is not even in DC, which is more backlogged in the court than I'm talking about. I filed a motion for summary judgment in a case in July and got a decision in February. So, they can take a long time for an actual decision to come out for actual summary judgment, the case is resolved type things. Oh, well, there you go. So maybe the contact form is more effective. I would still say if we can keep emails, that's easier, just to avoid the finger pointing between the NBC and the embassy. But if we're able to get responses using the contact form, then all for that. The more evidence we have, the better. You certainly can involve a senator or representative. They will probably get kind of the same response, but it's I think helpful for us if we're able to say, and Shirley here, contacted her senator and her representatives, and they all reached out to the Frankfurt embassy, and they all kind of got these non-answers about when cases would start moving. It's definitely more powerful if we're able to say, even congressional representatives are getting involved. So yeah, I'd say reach out to them. It may move things, it may not. I've had experiences both ways. But yeah, that is something to do, and then also just keep the emails up.
This message is from Pam. What's the process for petitioning for an infant that is adopted without an agency? Really good question, and actually quite a complex question. A little bit beyond what we can get into in one of these calls. That's something, if you wanted to talk individually with us, we could do a consultation. I'll just flag that there are certain adoption-related issues that we usually refer out to a local firm that specializes in international adoptions and immigration. So it might be something that ends up there, but it's hard to know without knowing more.
Yeah, it's a lot more complicated than you'd think. Requires a lot of times, but there's multiple forms of international adoption. It's an interesting and complicated area of immigration law. Any update? Ron, you want to take that one?
Yeah, I was going to say this is something that I'm actually working on, so I can finally say something. We're working on the complaint for this case, and we're hoping to have it done as soon as possible. I would hope to have it done and turned in by tomorrow at the earliest, but we might have to push it to next week. We'll see. And yeah, I just wanted to give you that update on that situation. Had to call you out. So.
On H1 litigation, so I'm not aware of any, unless you're talking about, Acquia. No real updates to give on that. There's, just like all these other cases, kind of behind the scenes talking going on, and nothing really to give an update on. As far as any like more broad H1 litigation, I don't believe we have any major H1 cases going, do we?
No.
Didn't think so. Okay, so if it's Acquia that you're talking about, just still kind of behind the scenes talking, and nothing more to give on that one, unfortunately.
We already talked about London, so I think we can go to the next. And the Penn case, Zach, do you want to give an update on that one?
Yeah, I mean, so Penn's been filed. It's, the government's got its clock ticking there as well. I expect a preliminary injunction there filed not too long after. No news from the judge, and we won't get news from the judge until we've got government counsel assigned and we're able to really push the issue with either a preliminary injunction or negotiating with the government attorney. Yeah, that'll be the next step to keep an eye out for.
And for those who don't know, that's the Brazil K1 case, Penn. Let's see, it's Greg. This question from Amy. Greg mentioned research was being done on whether 01 Kinsley plaintiffs may also join the new 01 mandamus case to transfer over instead. The update on that is it's going to be possible. We think that really we're going to have to dismiss you from Kinsley right before the new 01 case is filed. But if you fill out the onboarding for the new 01 case, we will sort that out for you.
So the issue with joining two lawsuits is you can't have two claims that are the same going at the same time. And it's I guess easier to conceptualize if you're thinking about just two people suing each other. Like you couldn't sue the same person over and over again for the same thing. So if you're in Kinsley where we're saying, hey government, we're suing you over the travel bans and the travel proclamations, joining another suit that's also suing that exact same thing, this is not allowed. So just requires, I guess, a little bit of logistical hoops to jump through of dismissing and all that, but definitely possible. This is unfortunately a lot of folks are in this situation, and Paris is in particular kind of overwhelmed with interviews. What you can do if your company is able to demonstrate it is try to file an emergency or an expedited appointment. Beyond that, I mean, the thing to do is to hope that consulate capacity really opens up and we're able to really push for new interviews. It's unfortunate that, this is just kind of the way things are. As soon as, when you have a year where certain types of visas can't be issued, and then, even beyond that, we have the travel proclamations in place that are saying no visas will be issued. There's just a huge backlog that develops, and this is kind of the result of that. Interviews being scheduled out for a year, unacceptable, and hopefully something that can be fixed on the side of state. And if not, then perhaps your employer can push for an emergency appointment.
Let's see, John's question is it up to a judge to order relief, or should relief just happen? If it's not up to a judge, do plaintiffs need to chase relief? What's the difference between mandamus and getting relief? Well, relief is really what we're just referring to in the context of a lawsuit of what we're asking for. So yes, it's up to the judge to order what we're asking for, which we'll call relief. So what the relief is different than in each particular case. For example, in Kinsley, the relief requested was that the government would not be able to rely on proclamations and under a statute. It's 212F in the Immigration and Nationality Act, that they weren't going to be able to rely on those to refuse to process visas or refuse to issue visas. That's the relief requested in Kinsley. As for what's the difference between mandamus and getting relief, a writ of mandamus is basically another kind of relief. It's ordering the government to do something that a duty that they owe to a person. In most of these cases, the duty that we're asking for, if there's a mandamus case included, is that the government must adjudicate the visa application. That's what we're asking for. And so those are different things that Kinsley is not a mandamus case. Some of the other cases are. So that's the difference. But yeah, relief depends on what's asked for in a particular case.
And of course, the government can always settle with us, and we can receive relief that way. We could. That's been happening in Milligan. The plaintiffs have been getting the relief we're seeking just by settling with the government attorney, saying, "Hey, this person and that person, push their cases along. Let's go," more or less.
This question from Jennifer: have the filing fees changed for adjustment of status yet? No, they have not. They're enjoined, and they're not going to change anytime soon. I don't know. I don't remember if the Department of Homeland Security formally withdrew the regulation that was trying to raise those fees. They may have, but either way, they're enjoined, and so there's no expectation that they're going to be raised anytime soon. It'll be another. Whenever they do it, they're going to file another notice and comment period. Could be this year, could be in 5 years. We don't know when, but you'll have plenty of warning.
Yeah, that's part of the problem. It's a whole bunch of lip service that we've been getting. Here's an announcement saying you're top priority. Here's an announcement saying, K1s are, first and foremost of all visas that will be processed. And then we see on the ground that it just doesn't happen. That's why these cases don't just kind of go away when these announcements go out. And that's why we're pushing this. I guess we have sorry.
No, go ahead, finish up, Zach.
I was gonna say we gave kind of an update on where Kinsley's going earlier on, but as of now, just keep emailing the embassy and the NVC and collect that evidence.
The question is, for Go plaintiffs, do we need more confirmations of refusal to transfer cases to other consulates for the exhibits? So for people who don't know, Go plaintiffs have been emailing those to us, and we're going to be using them in the lawsuit. Thank you for asking, Alexander. I'm pretty comfortable with where we are. If I didn't get any more of these emails that show the government's refusing to transfer cases, I would be fine with it. That said, if you have any that you think are particularly compelling, you're always welcome to send them to me, and I can decide to actually use them or not in the filing.
Yeah, Manila is a problem. So we filed the new lawsuit, and hopefully, that will move things along. They have given another kind of like lip service announcement that they're prioritizing K1 visas, but like you've experienced, they're not responding, and they're kind of giving these generic responses that, hey, we're just not doing it. I know that we had at least one person in Milligan who was recently interviewed or scheduled for an interview at Manila, and hopefully with this new lawsuit also pushing along, things will kind of open up there. It's really kind of silly that Manila, of all places, is deprioritizing K1 visas. Of all the consulates in the world, they're the #1 K1 visa issuing consulate. So their folks are trained, they're experienced on that, and then the fact that they just decided, nope, we'll do other things, doesn't make sense, especially with explicit directives from Department of State higher ups saying prioritize these visas.
Can you get travel authorized right away for emergencies? I'm not sure the context of this question, because it may be for people who have entered on K1s and then are trying to get travel authorized before they get their adjustments done, or it might be for people who are still trying to come to the United States. Either way, yes, emergencies are considered, at least to some extent, and there is mixed success, but either way, yes, emergency circumstances are considered by USCIS if it's here in the United States and you're applying for advanced parole, or the Department of State if you're applying for a visa from abroad.
Absolutely, yeah. If they're not really processing cases, we can absolutely sue and say, this has been too long. This is an unreasonably delayed case. Get this moving, consulate. The fact that they are really trickling in with the smallest number of K1 applications possible doesn't preclude a lawsuit by any means. And in fact, it might even help the lawsuit for us to say, hey, there's at least they have the ability to process these visas. but they're only doing 4 a month or whatever it would actually be. That all we have to demonstrate is that the cases have been unreasonably delayed. And that's not a bright line. It's a very much a balancing test of a bunch of factors, but yeah, absolutely, we could still sue.
Eddie's back with more K1 work authorization questions. So how long, if they do stamp it, how long does the work authorization last? They can, so your work authorization, like we said, is incident to status. And so if the 90 days is the end of your status, they're probably going to mark it with an expiration date of the 90 days. Hopefully your actual work authorization card will be coming, shortly thereafter, to minimize any gap. But yeah, it's probably going to be limited to that 90 days. Ignatius, hello Ignatius. We've emailed before, so nice to see you. Nice to see a question from you. So the question here: what's the earliest time we could get a ruling in the case, considering the category ages out in September? Yeah, I mean that's the whole point behind the case, is that the category has a deadline of the end of September, and so that's why we filed it when we did. That's why we raised it back with Enunciado, and so we know that the court's well aware of that already from the complaint. They'll be well aware of that from motions that are filed in between now and then, or any status conferences. And so there, it's hard to guess at a specific timeline. I would say the earliest time we could get a ruling, if I just do a little math, I don't know, June. But I doubt. I think that's overly optimistic. I think it's going to be more towards July, August before there's a ruling. Same question, same person, Ignatius. Can we get a redacted version of the complaint as filed? Yes, you can. And we have that. Actually, I think it was supposed to be sent out to all Go plaintiffs, but there was an issue with the email list, and so I don't think that they've received it yet, but I will check into that. In the meantime, if you could just sit tight so that I don't get 700 emails asking for the same thing, I would appreciate it.
Yeah, exactly. So really their answer there is that regulations require in-person interviews, but I think that's up to interpretation, and you could say, that this is in person when you're having, two people on opposite sides of the screen. They're doing, for example, naturalization interviews virtually right now, and those also require you to be, judging the body language and all of that of the applicant. So I think it's possible, and it's kind of a weak excuse. The difference is that the 01 lawsuit would have a mandamus component, where Kinsley does not have a mandamus claim. So Kinsley, we're saying you cannot use the proclamations to refuse to issue visas, and the 01 case would have that claim in addition to a mandamus claim saying that the specific cases in that lawsuit have been unreasonably delayed, and judge, please mandate that those cases get moving.
Keith wants thoughts on immigration reform. First, the 11 million. I assume that means some kind of legalization program for 11 million people without status, and then also for the second essential worker. The Biden team put out, or at least drafted, some version of a comprehensive immigration reform bill, and they provided it to some members of Congress right around the time of inauguration. In my view, it wasn't sent really with any conviction that it was going to be passed as is, and there is at least some serious issue with getting enough members of the Senate on board to pass anything. And so it seems that it's more likely that it's going to be broken up into various bills that some may have a chance of passing soon, some may not. For example, the most recent version of the DREAM Act tends to usually, the DREAM Act tends to have more bipartisan support. And so whether the Senate will actually move it, I don't know, but I would think that that would have one of the best chances of moving. Zach, what are your thoughts on all of that, and also on the second category EB cases that I think?
Yeah, I agree. When it first came out, I was not optimistic that that was going to be one of the first priorities of the Biden administration, really to push through comprehensive immigration reform. I mean, there was just other legislative priorities that kind of they were more immediate. And the Biden administration was fully forthcoming that they were willing to break it up into smaller bills, which we've seen through the DREAM Act, like Aaron mentioned, and then the Promise Act as well. As far as kind of like an immigration reform that would allow for some sort of, if you want to call it amnesty or whatever you want to phrase it as, for the 11 million undocumented folks in the country. I don't see it happening in the immediate future. What I would really like is just some kind of smaller reforms that would kind of take the pressure off of undocumented folks and give them some more pathways towards legalized immigration status. The biggest being, I think, the 3 and 10 year bars and the permanent bar that happen if you depart the U.S. after being here for an extended period of time without status. If those were removed, suddenly a whole bunch of people would have access to lawful immigration status that they wouldn't otherwise. So that's what I'd like to see. I'm not confident that there would be some big reform that would make this pathway for the 11 million folks. And same thing with the essential workers part of this. It's really good PR to say we're going to ensure that the folks that are on the front lines and that have been really bearing the brunt of the COVID pandemic will be rewarded for that. But I guess in Congress itself, I just don't see it happening. Maybe it's pessimistic to think that, but that's just how I view it. A positive result would apply to non-plaintiffs. Yeah, I would just say that, hey, the no visa policy is illegal. No, we can't do that. Will another lawsuit be filed for non-immigrant visas? Potentially. Maybe it would be probably a much more targeted lawsuit like the 01 lawsuits have been. It's hard to say. We would have to get the plaintiffs for it. And then it would be a case-specific type thing. If we're saying, for example, this particular visa category as a whole has been delayed unreasonably, it's a lot harder than for us to say these folks who have been waiting for a year, who've been waiting for over a year, have been unreasonably delayed. So possible, not certain by any means, but could happen.
Well, the question is whether the July bulletin becomes current or not. Yes, I'm presuming that this is about diversity visa questions, and it's current, yes, almost across the board. What is the benefit of all the cases going current? The benefit is that every person with a current case will be able to say that they should be scheduled for an interview. There's no excuse from the cases not being current. Now, like I said, that doesn't resolve the issue of them not scheduling interviews at all for DV cases. And it certainly doesn't guarantee that everybody who's current is actually going to get a visa. But it removes one potential barrier or one potential excuse for Department of State not to work a case. So what are the chances of somebody who's not documentarily qualified to get an interview if the lawsuit is won? I assume that just means, Nabil, that the Department of State hasn't said that you're documentarily qualified, not that there's some underlying issue with your case or your eligibility. If so, I don't know. I mean, I hope that you've sent in your documents to KCC and that they're reviewing them, and that they'll make an official ruling that you are documentarily qualified soon, and much before there's a decision from Judge Mehta. So I don't know, but I don't think the fact that you're not yet documentarily qualified necessarily means that you don't have a chance to be interviewed or get a visa.
Yeah, this is, again, the regulations say that the immigrant visas have to be, for an immigrant visa, the interviews have to be done in person. At least that's the excuse that's been done over and over. I think that you could make the interpretation that in person includes a virtual virtual meeting of some sort. But as of now, no.
This is something that we've talked about before, but it's just crazy. I mean, you have to, it's a global pandemic and everybody's gotten creative about how to make their lives work, their work, their everything else work, courts, other agencies. And think of all the ways you could get around this. You could do pre-screening by Zoom if you wanted, and then have the official interview just be at a walk-up tent with just a couple of minutes right on the sidewalk of the consulate. Or there's just a million things you could do to make this work with technology. Or you could interpret the requirement, like Zach said, to include video interviews to be in person. There's a million things they can do. They're not doing them, and that's the reason that we have this backlog and all these problems.
And beyond that, like, it's not even that just the interviews are what's being stopped. They're just not processing cases altogether. When you send your documents off to to be processed, to be sent to the embassy, they're just not doing that either. And that doesn't require any in-person anything. You could do that. The Department of State employees could do that from home, in their pajamas. So yeah, it's ridiculous, and why we're suing. I guess it depends on your specific circumstances. If you have a good mandamus claim, then having, being in a case with a mandamus component to it is certainly better. If you are, let's say you only just had your case into the NBC in like January or February, that's not a great unreasonable delay claim. So less likely to get the relief that you're looking for there. Yeah, I guess it's very case specific in that front.
All right. Alexander says it's the last question for him, and it's the last question for all of us because our hour's about up and we have to get on to other things. The question is, why are we asking and go to reserve 55,000 visas and not just for the plaintiffs? Because that's a lot to ask and hard to process. Well, the plaintiffs are in varying circumstances and varying case numbers and varying circumstances in the individual consulates around the world that they need to get their visas from. If they don't issue all 55,000 visas allotted by Congress, then some of the plaintiffs are going to be left out. It's not just a matter of order saying, just get them these plaintiffs to the front of the line. They have different circumstances, and without having having Department of State issue the visas allotted by Congress, people are going to be left out. So we need that in order to get as many plaintiffs as possible their visas. Does that mean that they're going to be able to issue 55,000 visas before September 30th, even with a court order? I doubt it. They're not even trying right now. They issued, I think, 20 in March after the lifting of Proclamation 10014. So I doubt they can even ramp up and do it, even if they try. But what we can say is this is this situation we're in is a result of bad faith by the government in not issuing any visas up until March. with an unlawful interpretation of the proclamations, and that they're not making a good faith effort to catch up now, and that therefore, if they're not able to issue a certain number of visas by September 30th, then they've got to reserve them and issue them into the next fiscal year. That's why we're in the District of Columbia, because Judge Mehta has already ruled in the context of DV 2020 that he has the authority to order visas issued into the next year, the next fiscal year. And so we think we're in a good position to get that and get as many plaintiffs as possible their visas. All of that said, we are also asking for the plaintiffs, just the names plaintiffs, to just be adjudicated. That's one of the asks. So it's two things: adjudicate our plaintiffs, and also, so that as many people as possible can enter, reserve all 55,000. I think that's it. Thank you all for joining us, and thank you for your good questions. We will be back next week, same time, same place. Thanks, Zach. Thanks, Ryland, and we'll see you all later.
Bye, everyone.
See you later.